Hi, my name is Caesar and welcome to Tips for Landlords and Property Managers brought to you by FastTV.com Law Group. Hi there, my name is Caesar and welcome to another Tips for Landlords and Property Managers video. Today, we're going over a few things to consider when it comes to tenant damages versus wear and tear in California. Remember, this video is not intended to be legal advice. Please contact us for a free consultation. Did you know that according to a Porch.com survey, 23.8% of renters think a landlord has unfairly withheld part of their security deposit? It's important to mention this because this is where landlords and tenants never seem to agree. Now, let's make one thing clear. Landlords can't just withhold any amount they want from the tenant's security deposit. This means they can't dispose of it as they see fit. There are California laws in place regarding the use of security deposits. For example, landlords must return the tenant's security deposit in part or in full within 21 days of them vacating the property. If a deduction was made, landlords must provide proof of costs. The law allows landlords to deduct from the security deposit to cover the cost of damages caused by a tenant. Landlords cannot deduct normal wear and tear of the tenancy or the expected depreciation of a property. What is considered normal wear and tear? Normal wear and tear in California of a rental unit is defined as the physical deterioration that occurs with normal use. This does not include your tenant's negligence, carelessness, accident with, or abuse of the premises, fixtures, or chattel property. Normal wear and tear is deterioration or depreciation in value by the ordinary and reasonable use. Signs of normal wear and tear include worn electrical switches, frayed pull strings on blinds, slightly scuffed hardwood floors, loose caulking, peeling wallpaper, faded curtains, dirty window screens. What is considered damage caused by tenants? When a tenant causes damage beyond normal use of your property, a landlord has the right to charge the tenant of the damages. These include damages inflicted by your tenants themselves, their guests, or their pets. Here are some examples of normal wear and tear versus damage. Matted carpeting versus burnt or stained carpet, a reasonable number of small nail holes in the wall versus large holes in drywall, fingerprints and faded paint versus large stains, ripped wallpaper, or broken moldings. Please keep in mind that if you deduct part of your tenant's deposit to fix damages, you must provide an account for the expenses along with receipts. Something else to keep in mind is that if the tenant disagrees with you, they may file a claim against the landlord in court. To prevent legal issues, make sure the damages don't stem from neglected maintenance to your rental property. For example, the wall behind the door is missing a doorstop, and now there's a hole in the wall where the doorknob caused damages. Leaking or dripping pipes can cause damage quickly and destroy cabinets and floors. Windows, which are not securely shut, can allow water from outside to damage woodwork and flooring as well. Any damages that could have been prevented by the landlord will certainly find disfavor with the judge. Normal wear and tear is often determined by the length of tenancy coupled with the useful life of assets on your property. Here's an example. Carpet's useful life is anywhere between 8 to 10 years. If you haven't replaced your carpet for 8 years, you shouldn't charge the tenant who lived on your property for 2 years the total cost of replacing the carpet. If your tenant has occupied the unit for 3 years, it's reasonable to expect a fresh coat of paint and a deep cleaning of carpets once they move out. At the end of the day, property owners typically bear the cost for normal wear and tear maintenance. Have you been involved in a dispute due to a normal wear and tear damage issue? We'd love to hear about it. Thanks for watching. Please share if you found this video useful. I'll see you in the next one.